After my last video on how sometimes doctors and nurses in hospitals will blame genetics for a baby's HIE or subsequent CP diagnosis, I got a message from someone who said that they or the families that they know didn't even think to look for help because they believe that the doctors and the nurses, that they did not intend to hurt their baby. And I get it, I understand it. A lot of families struggle with this. It's hard to think about your doctors or a nurse as doing something wrong, especially if they were not trying to cause harm. But here's what's important for you to understand. When it comes to these cases, intent, what they intended to do, that is not the standard. That's not what we're looking at. In medical malpractice cases, the issue is not whether a doctor or a nurse meant to cause harm. It's about whether they followed the standard of care. If they did not, and that failure is what led to your baby's injury, an HIE diagnosis or a subsequent CP diagnosis, that is negligence. Think about it this way. Let's look at it like this. If a driver runs a red light and crashes into another car, they probably did not mean to hurt anybody. They didn't intend to hurt anyone when they ran that light. But that does not change the fact that their actions have caused harm to the other driver. The same applies to medical professionals. Just because they did not intend to cause injury does not mean that they are not responsible for their actions or what happened. If they were negligent, they are responsible. But this belief, if the doctor did not mean to hurt your baby, there is nothing that can be done, stops a lot of families from getting the answers that they deserve. And the reality is that hospitals and their legal teams, they know this. And sometimes they are hoping you take no action against them if they were negligent because of that thought process, because of thinking that they had to intend to cause harm. The longer that families wait, the harder it can be to investigate what really happened during your labor and delivery. Medical records can be misplaced or they can become harder to access over time. Memories of what was said and done in the delivery room, they can begin to fade. And in some cases, legal dead limits or deadlines, I should say, like the statute of limitation, they can bar any type of action by the family at all. Meanwhile, hospitals do not wait. Their legal teams are already looking at how to defend these cases even before families start asking questions, a lot of times when there is an HIE or other type of traumatic injury to the baby. And that is why waiting, if you are unsure, can put families at a disadvantage. You do not have to know for certain whether medical malpractice happened, but getting informed now means that you will not lose the chance to act later if you need to. And I just want to be clear with this. Reaching out does not mean that you are going to immediately file a lawsuit. It just means that you are taking the time to understand what options you may have. With my firm, our initial investigation into these cases is it costs no money up front to you at all to do this. So you don't have to worry about that initial investigation part and shelling out money for that. Again, I'm Marcus Boston, and if you have any other questions about your baby's HIE brain injury at birth or subsequent CP diagnosis, if you have any of those types of questions from a medical legal standpoint, don't hesitate to reach out and contact me. If you're on certain apps, you can send me a DM or you can just click my profile. You can find out more information about me there in my profile, or you can just wait and check the picture out that follows this video. All right, that's going to be it for this evening's short educational video. Have a great weekend, everybody.